Well, good afternoon, everyone. Um, my name is Dave Scott, and I work for the Office of the Indiana State Chemist. Um, it's my pleasure to be here again at the Purdue Pest Management Conference. Um, I'd like to thank the program organizers and program sponsors for inviting our agency to participate in the program again this year. This is the 88th um, Purdue Pest Management Conference. I've had the fortune to be participating in one form or another uh, at the conference since about 1979, when I started my pesticide regulatory career with the state chemist's office. And it's great to be back here again. Um, you can see by my title slide, um, this will be viewed on January the 10th. Today is November the 27th. And I point this out to you. Um, Perhaps it's not going to be important, but we're going to be talking about some regulatory changes that will include rules and laws and different activities um, that are sort of in process right now. So there's a chance by January 10th, we may have some additional updates, or some of the material I'm presenting today may be a bit dated. But I'm sure I hope to be able to lay enough of a foundation here today that even if we do have things that change in the not too distant future, that you'll be able to keep up with those changes. What I hope to visit with you a little bit here today are several different things. As I've already indicated, we're going to be talking about some rule changes over this past year. We're going to be talking about some law changes over this past year, and we're going to be talking a little bit, as I've already sort of given you a spoiler alert. We may be um, talking about some new legislation in the 2024. And as time permits, I'll also try to share with you a few other items that may be of some interest to you, that not necessarily laws or rules, but the things that our agency has been engaged in over the course of the last year. We're going to start with the rule changes from 2023. And when we're talking about these rule changes, we're talking about some changes to the rules that the Pesticide Review Board and that the State Chemist's Office have been working on since for about the last 4 years or so, since probably 2018. And these rules um, were necessitated in response to some federal pesticide rules that were changed by EPA in 2017. The and they have to do with those rules have to do with the certification and training of pesticide applicators. And in a nutshell, um, states, many of which have their own set of requirements for applicator certification and training. Um, what the federal rule said is state rules have to be comparable to federal rule to allow a state to continue to run its own program. So that's why we started on the rule revision process back in 2018. And just to give you an idea of how we arrived at the final rule, it's the same way we've made rules in over the course of the last 40 or 50 years or so, or at least since I've been involved with the agency. It's pretty much a negotiated rulemaking process. In other words, we do it publicly, usually at the quarterly pesticide review board meetings, um, with all the stakeholders, or hopefully all the stakeholders present, and folks that have concerns or thoughts or input into the rulemaking are all there and have the opportunity to participate throughout the entire process. Um, so that's what we've been that's what we were going through, and that's what resulted in the rules that became effective this last year. So what changed in 2023? Um, a number of things changed in the three basic pesticide rules that we're responsible for. We moved some things around from one rule to another to places where maybe it made more sense. But probably the biggest items the most significant items that changed as a result of the 2023 rules was uh, we revised it and required that restricted use pesticides be applied only by certified applicators. In other words, there was no longer a provision for direct supervision of non-certified applicators when it comes to application of restricted use pesticides. In addition to that, we tweaked the record keeping rule a little bit for restricted use pesticides. The only addition to the existing rule was that we added a provision that you need to incorporate in your application record both the start time and the stop time of your application. That becomes important a number of places, but in particular outdoor applications where winds can pick up or die down based on what part of the day you're making applications. Actually, in any weather condition uh, could fluctuate during the course of a day. So that was the change we made to the record keeping requirement or record keeping rule. Uh, the other change that was made was to become a registered technician and to apply a pesticide under somebody else's supervision for general use pesticides. It used to be you had to pass the core exam to qualify to become a registered technician. Additional options were added to that. Um, you can now either attend a core training program without taking an exam or attend a training program that's designed specifically for the registered technician. And both of those, the core training and the registered technician training, are both programs that are administered and presented by Purdue, Fred Whitford and Purdue Pesticide Programs. So those were new options under the rules that were adopted this year. And the last one is one that probably does not impact your industry all that much, um, but we modified the bulk pesticide storage and containment requirements a little bit, in particular as they apply to the handling of mini bulk pesticides. And mini bulk is defined in the law as any container that would hold from 55 to 400 gallons. We reduced the number and the extent of the requirements for mini bulk containers. And again, my guess is most of you folks don't deal with containers that large. So those were the major changes that were enacted this year. They actually became effective January 4th of last year. So roughly 1 year ago. We used the entirety of 2023 for outreach and education and compliance assistance to help folks get used to the new requirements and to come into compliance with those. And we anticipate that January 1 of 2024, we will start the compliance work and the enforcement work to ensure everybody's up to speed on the new standards. And I've indicated, at least on my slide, that maybe that will be the start date. And I say that because what comes next, and what we're going to talk about what comes next are some law changes that were enacted during this last year, and these were not laws that were law changes that were anticipated by the state chemist's office. So some of our brand new rules that have not even been in place, not even a year yet, may be subject to change. And we'll talk about that a little bit here in a few minutes. Before I move on to start talking about laws, in a regulatory program, I guess it probably doesn't make a whole lot of difference to the regulated community whether the requirement is created in law or whether the requirement is created in a rule. The bottom line is they're both they can both create regulatory requirements. Um, the regulated entities still have to comply with them, whether they're in law or whether they're in rule. But how you get to the requirement is probably the important point. And I'm not trying to speak down to anybody, just to going into providing a little bit of background as to what's the difference between a law or a rule. But it might help in your understanding of why we sort of are where we are now. Laws are requirements or provisions or policies that are developed initially and then amended by the Indiana General Assembly. In other words, our state legislature. Neither the Pesticide Review Board nor the state chemist's office. Neither of us are responsible for or have the ability to develop or amend laws. That's done by the legislature. And we have two pesticide laws in the state of Indiana: the pesticide registration law and the pesticide use and application law. And again, that's the purview of the General Assembly. Rules, on the other hand, are regulatory requirements that are developed by either the Pesticide Review Board or the state chemist. But routinely, the way we have operated, it's usually both of those entities working in concert to come to a agreement as to what the rule will actually look like. We have three major sets of pesticide rules in Indiana, and you can see the citations there. First, dealing with pesticide certification and licensing. The second, pesticide storage and containment, and the last, pesticide use and pesticide use restrictions. Now, even though the Pesticide Review Board and the state chemists we write those rules, it's the Indiana legislature or the General Assembly that actually determines what rulemaking authority that both the board or the state chemist's office will have. And if the legislature has not granted rulemaking authority for a certain type of activity, then neither of us are allowed to write such rules. So that brings us to 2023, and in particular, House Enrolled Act 1623. It was introduced obviously this year. It was passed. Now that it's a House Enrolled Act, it's no longer a bill. It was passed and it was signed by the governor. And again, this is not a law that law changes that the state, not either the state chemists or the Pesticide Review Board or industry, our regulated industries, as far as I can tell, for the most part, were seeking, but they occurred anyway. And I would characterize, personally, 1623 as a pro-business and deregulation type of legislation. That's my opinion. You can draw your own opinions on that, and we'll cover here just a little bit about what all that entailed. But if you look at the digest for this law, it says it was intended to do several things. First of all, it established the Government Reform Task Force, and the Government Reform Task Force is a task force made up of state legislators, and they are tasked with oversight responsibilities, looking at monitoring what state agencies are doing with respect to their regulation, implementing regulations, and the regulation of regulated clients, trying to make sure that we in our compliance work and our enforcement work are not running off the rails or getting terribly out of control. So there's an oversight function that was created. 1623 also prohibits the consideration of the number or amount of fines or civil penalties imposed on regulated entities by an employee in an agency's evaluation or compensation. Honestly, the first time I read that, I didn't know what it meant. So I did ask our staff attorney, can you tell me before I try to explain to people what this means? Can you tell me what it means? And he says it means that that we can't base somebody's performance or give them performance bonuses or merit evaluations based on how many violations that they document or how many civil penalties they're responsible for. And I found that I found that because it's so foreign and ludicrous to with respect to our operation. I found it funny that somebody actually had to put that in law, but apparently some agencies may have been guilty of this practice. I say guilty. Some agencies may have used this practice. We never have. So one thing I did learn about this, the first time I explained it in public, I joked about it and told our staff, well, there'll be no more pay bonuses or bounties for you guys for the violations you document. And I did not say publicly that I was just kidding. I assumed everybody laughing in the audience, everybody assumed I was joking, but apparently not everybody in the audience took it that way. So I will say that's a joke. We've never done it. We've never considered it. So that's not going to impact our operation. 1623 will also make changes to how rules are adopted by either the Pesticide Review Board, the State Chemist's Office, or really any agency that has rulemaking authority, not just pesticides, not just our group. 1623 also prohibits state standards for disposal of coal combustion residuals to be more stringent than federal standards. That's a requirement that's directed squarely at the Indiana Department of Environmental Management because they regulate coal combustion in the state. 1623 permits a person to recover attorney's fees if an agency issues an order that is based on invalid rule or issued without legal authority. In other words, if we took an action against you or required you as a regulated individual to do one thing or another, and we did not have clear authority to either write that rule or issue that order. In other words, the General Assembly had not given us that authority, and it would therefore be an invalid rule. You would be eligible to recover your attorney's fees from us for taking that action if attorney fees were required. And then lastly, and this one is pesticide specific. Most of the other things would apply to all agencies in the state. But the last one, pesticide specific, prohibits pesticide rules for general use pesticides that are more stringent than federal law. And when we're talking about pesticides in federal law, we're talking about requirements under FIFRA. And we'll get into that here in just a second. Okay, so looking at the specifics of what of some of the pesticide amendments in 1623, what changed? They added the legislature added a definition of general use pesticide to the statute. Previously, the entire statute was written pretty much in terms of pesticides as opposed to designating certain requirements for general use pesticides or certain requirements for restricted use pesticides. So EPA the definition of general use pesticide legally is new to us. Previously, we had pesticides that were classified as restricted use pesticides, and if it was not an RUP, then it was an unclassified pesticide. So they introduced a new term, but general use pesticide is the term that most folks use, correctly or incorrectly, for products that are not restricted use pesticides. So that's what it means legally and officially. in state statute now. And I will say because our pesticide laws are written throughout with the term pesticide being used. But now that we've introduced the concept of there are differences between restricted use pesticides and general use pesticides, it's created some confusion in our minds with respect to um, requirements that may apply to either general use or restricted use, or maybe they apply to both. And in some instances we're not real sure. Um, so anyway, looking at um, some specific language was added. Section 52 and .5 was added to the law. It says neither the board nor the state chemist may by rule or otherwise impose requirements or limitations on the storage, distribution, use, application, or record keeping of general use pesticides by any of our licensed credential holders. That is more stringent than requirements and limitations applicable under federal law, federal regs, or Indiana statutory authority. So in other words, and in a nutshell, what that means that we're not, when I say we, it means that state chemists or the pesticide review board are not allowed to develop, adopt any new rules or requirements for general use pesticides for any of our licensed applicators unless those requirements are specifically required by federal regulation, meaning EPA, or unless they are specifically in state law. In other words, the General Assembly has made the decision this will be a requirement for general use pesticides in the state of Indiana. Section 52.5 goes on to say a rule or other requirement or limitation of the board in effect on June 30th, 2023 that does not comply with this section is voided on July 1st, 2023 to the extent it conflicts with this section. In other words, what it means is some of the rules relative to general use pesticides that we already have on the books, they may have been long-standing rules that have been on the books for 10, 20, 30, 40 years, or even the ones that became effective just January 4th of 2023, old rules or new rules. If some of those existing rules were to have been repealed and are no longer enforceable effective July 1 of this year. So the exercise we've been going through since that time, since passage of 1623, is trying to figure out every requirement that this new set of restrictions applies to relative to general use pesticides. And since we're throwing away, not throwing away, but throwing around the term nothing more stringent than federal requirements, the question we need to ask is, so how does FIFRA and the regulations thereunder, how does it regulate general use pesticides or non-restricted pesticides? What's the extent of those regulatory requirements? And if you read through FIFRA and the regs thereunder, a lot of what FIFRA does is applies to restricted use pesticides, not general use pesticides, with a couple of exceptions. And the first is users must follow label use directions. In other words, the label is the law. And the label is the law, whether it's a restricted use pesticide or a general use pesticide. So failure to comply with label use directions and restrictions would be a violation for the use of either type of product, and it would be a violation whether you're a certified and licensed applicator or not. So label is the law is still in play. You look beyond that and you look at regulations that EPA has developed for general use pesticides, and you see it only in a couple of areas. One is federal rules for bulk pesticide storage and containment. We've already talked about that. Those are rules that don't impact you all much because you don't store products usually in those size containers, and that applies to both RUPs and some GUPs. The other one would be the EPA's Agricultural Pesticide Worker and Handler Standard. That deals with the use of agricultural pesticides. Again, mostly products that you all do not use. But again, that set of requirements applies to ag products that are either restricted or general. It applies to users of those products, whether they be certified and licensed or not. So you see, it's a relatively small universe that the feds regulate with respect to general use pesticides. So we look at, we tried to identify and went through all of our requirements, all of our rules to try to figure out what things did the legislature obviously intend that we stop regulating. And we identified certain things that seemed very clear to us that they wanted deregulated or eliminated. Those would include advance notice of a pre-construction termite control treatment. And again, we've got a state for those of you who do pre-construction termite treatments. There's a requirement that you notify us in advance of that planned treatment, but either by phone call, email, fax, whatever. You are no longer required to do that. The requirement that certain applicators, commercial applicators that use general use pesticides, whether they be at schools, at golf courses, or for community-wide mosquito control, current requirements were that all of those folks making application at those sites or for those purposes, whether they were RUPs or GUPs, was required to be certified. That's gone. Requirement for hands-on training or previous experience or a post-high school turf degree if you wanted to become a fully certified and licensed Category 3B applicator and apply pesticides for hire. That requirement is gone. The requirement that certified and licensed Category 3B applicators post or flag lawns immediately after treatment, that requirement's gone. The requirement that lawn care applicators provide their customers with written notification of what was applied and what it was used for, that requirement is now gone. And some record keeping requirements. Record keeping for general use pesticide applications, whether it be made for hire, whether it be made at schools, or whether it be made at golf courses. There were record keeping requirements for all of those pesticide uses and users. Restricted use or general use. The general use record keeping requirements are now gone. And then lastly, and this one may not impact you folks much, or at least it hasn't much historically. We've had a state drift rule that said if you drift a pesticide during application off target in sufficient quantities to cause an adverse effect to the non-target site, that was a violation of state law. That drift restriction no longer applies to general use pesticides because EPA does not have a similar requirement. So those are the ones that we know for a fact, and those are the ones that we stopped enforcing and doing compliance work for effective July 1 of this last year. The next class of requirements for general use pesticides are ones that we believe are still in place. We are still implementing these requirements. So because they were not specifically addressed in the legislation, the requirement for those individuals wanting to be fully certified in Category 7B to apply general use termiticides for hire are required to attend a 2-day hands-on training program. We believe that to be still in place. The requirement that termite control applicators for hire must disclose to their customers anytime they make a less than label termiticide application. We believe that is still in place, and 1623 did not touch that. The requirement that that applicators have access to a full copy of the label of the product when they're applying general use pesticides. We believe that's still in place. And then lastly, a number of requirements with respect to the application of general use pesticides at schools, whether it's being applied by a licensed applicator or by a school employee. The applicator or the employer are not to apply when students are present. That's still in play. They're required to keep students and staff out of treated areas until the spray has dried. That's still in play. Required to apply rodenticide baits in areas inaccessible to students. That's still in play. Requirement that if you're going to store pesticides at school, you store them safely. That's still in play. And lastly, the requirement for a notification registry for students and staff. And that's really a requirement for the school, less so for the certified applicator. But that we believe that still to be in play. There's a third class of requirements that we think might be eliminated, might have been eliminated, or might have been intended to be eliminated. Based on our uncertainty, we are looking at seeking some legislative clarification in 2024. And the only way that we're aware that we can do that with any degree of certainty is to address it specifically through law changes in 2024 because of our uncertainty. And those items or those requirements that if we don't get them clarified this year, that may go by the wayside. The requirement to have a business license to apply general use pesticides for hire. We're not, even though it's referenced in the law right now, we're not sure if the intent was for that to be eliminated or not. So we're including that in our legislative proposal for 2024. The requirement that if you're applying general use pesticides for hire, that you be certified and licensed. We're not sure if that was intended to be deregulated or not. So we're pushing that question as well. The requirement that if you're applying general use pesticides and you are not a certified applicator, that you have direct supervision from a certified supervisor. We're not sure if that was intended to stay or to go away. And likewise, the technician registration program. And we just referenced that earlier. There are now more ways as a result of our rule changes from this year, now more ways to become a registered technician. But we're not even sure that the technician registration requirement for general use pesticide users will still be in play. So that's one that may go away. And lastly, there's no specific reference to it in our pesticide statute, but I mention it because it's a sort of an unintended consequence of some of the potential unintended consequence of some of the deregulation that's occurring is right now under federal law and state law, if anybody who's applying a pesticide directly to waters of the U.S. or near waters of the U.S. where it could enter into the water body, is required to get a NPDES permit, and that stands for National Pollutant Discharge Elimination System. In other words, you got to get a special permit every time you make an application in or next to water. IDEM is the agency that's responsible for issuing those permits. IDEM, we worked with IDEM, and they developed a general permit for pesticides for the state of Indiana, and that general permit was based on the fact that applicators have been required to be trained, certified, and licensed. The fact that applicators have been required to keep records of those applications, um, and applicators have been required to follow the use directions, all of the use directions on those labels. So um, as we just discussed, the requirement to follow the label is still in play. But if the requirement for training, certification, and licensing, and the requirement for record keeping go away, the terms of coverage under the general permit may be required to go away as well. So the objective of our 2024 legislative proposal is either to clearly repeal all the general use pesticide requirements that the General Assembly wanted deregulated, or clearly incorporate some of those GUP requirements into law. So we hope to wind up in one place or another, so we know with some certainty what we're doing with respect to our regulatory program. Okay. I'm going to check time. We still have some time. I'm going to cover a couple of other items not related to rules and rule changes and law changes and those types of things. Just to let you know some of the things we've been up to over the course of the last year. First one being, and this is a milestone for us. It shouldn't be in this day and age, but we only this year gained the ability to accept a credit card for payment of renewal of your pesticide licenses. I'll tell you, it's not. We do not have a renewal process in place to the extent that we had hoped to. We're shooting for a completely online license renewal process, just like everybody else in the world has. But we don't have software, internal software that allows us to do that yet. A half step to that process, even though it's not completely online, it will involve some paper transaction associated with the credit card payment. But at least now, if you'd rather pay for your license renewals through a credit card as opposed to check, we do have the ability to do that at considerable effort, but it's been way too long in coming. So that's new for 2024, and maybe some of you folks have already renewed your licenses for the upcoming year, and maybe some of you have taken advantage of that payment option. In addition to that, in 2023, just probably like as we have done the last probably 10 to 15 to 20 years now, we participated in a clean sweep pesticide disposal program. Just to give you a little overview of that program, and I know many of you are familiar with this because many of you have already participated in the past. But again, this, as the name would suggest, it's a pesticide disposal program. It's open to anyone. Historically, most of our participants have been farmers or pesticide businesses that have unwanted pesticides. This is a low-cost option that allows you to get rid of those as opposed to paying the full disposal cost yourself. It allows for no question asked disposal of suspended, canceled, banned, unusable, opened or unopened, or just plain unwanted pesticides. If it's a pesticide, we'll accept it and dispose of it. The locations, this is a program that's run at about a half a dozen locations around the state. We usually conduct it about the same time, about the second or third week of August every year. You can see the locations listed there from 2023 and the weights, how many pounds of waste pesticide we collected at each of those locations. We try to move those locations around from year to year um, to hopefully make it closer to some of you in subsequent years. But you can see where a lot of these are fairground locations, co-ops, large pesticide handler locations. But that'll give you an idea of what we collected last year. In total, we collected over 77,000 pounds. And I will say for the fourth consecutive year, our total weight that we collected, the amount we collected, has gone up every year for the last four, collecting, as I said, over 77,000 pounds. And we had 162 different participants. So it's it's one of, again, it's primarily a non-regulatory program, very well received, and it's funded in part by US EPA. It's funded in part by our agency. Other participants in the past have included Purdue pesticide programs. They've taken some of the civil penalty money that's collected for violations and that we forward to them. They've used some of that for clean sweep disposal. And I can tell you that uh, we're already working on the program for 2024, and Purdue pesticide programs in Fred Whitford have expressed an interest to participate again. So I would say be on the lookout for that. Along about July, August, we'll announce the meeting locations and the meeting collection dates. Just to give you an idea of some of the products that were collected over the course of this last year, lead arsenate that was banned by EPA in 1988. Some 2,4,5-T, and 2,4,5-T was the major component in Agent Orange, which EPA banned in 1979. 1979 was sort of the first year that I was employed by the state chemist's office. And yes, I am that old. But that stuck out in my mind because I was brand new. I was a brand new pesticide investigator, and that was one of the first activities from EPA that I recall was the banning of 2,4,5-T. We collected a number of chloridane products that were banned by EPA in '88, and some chlorpyrifos products that were recently banned by EPA in 2022. I show you this, and we ask you to be on the lookout for this because this is a lead that actually came to us from a licensed pest management professional that was actually out making an application to a farm. It was a non-working farm. You can see by the junk pile there, and this licensed pest management professional, while he was doing his rounds of the farm, spotted some old containers of 2,4,5-T, and we just discussed that. Long since banned products, an old brush killer, but long since banned products. But this pest management professional turned the owner of the property on to the clean sweep program, and we got this old waste hazardous material properly disposed of. So your eyes and ears are certainly appreciated. If there's ever any question as to whether or not we can help with such things, this is one where the applicator took a photograph and sent it to us, and that's the best way to help us figure out how we may be helpful to folks such as this. So greatly appreciated. If you have any questions about the Clean Sweep program, we would encourage you to contact the program manager. His name is Nate Davis, and he'll certainly help you out with any questions. Lastly, I want to quickly go through the Endangered Species Act, the Federal Endangered Species Act, and in particular how it has been implemented under FIFRA. The Endangered Species Act was created by federal law back in 1973. I was a senior in high school in '73. I must admit I don't recall the Endangered Species Act being implemented or passed at that time, but I've since learned about it. And as you would guess, the intent of that law, it was designed to protect threatened and endangered species from extinction. Um, it's worth pointing out that the pesticide registration standard under FIFRA, whether a product gets registered or not, is a risk benefit decision. In other words, do the benefits of the use of a pesticide outweigh the potential risks? So it's a balancing act. Uh, with implementation of or incorporation of the Endangered Species Act into that registration decision, it tips the balance more to the side of ecological risk. Um, the Endangered Species Act requires any actions, any decisions made by federal agencies should not negatively impact the endangered species. So what that means to EPA when it's making its registration decisions or its reevaluation decisions every 15 years for a pesticide, have they considered potential impacts to endangered species? The major federal agencies that are players in helping EPA and others implement the Endangered Species Act are the U.S. Fish and Wildlife Service and the National Marine Fisheries Service. Um, just to let you know, the association, one of the associations that our agency participates in, the Association of American Pesticide Control Officials, we have put together a work group of folks to help us understand what is going on and what is happening with endangered species. Um, and we have been together for almost a year now. But again, uh, as far as major regulatory pesticide regulatory programs, I don't remember a program, uh, maybe except with the exception of the agriculture worker protection standard that is going to impact so many products on such a broad scale as what the Endangered Species Act has the potential to do. Just to give you an idea of the scope, when we talk about endangered species, of how, what are we talking about and how many are they? You can see for Indiana, we have 59 listed species in the state, nowhere near, for example, the state of Hawaii, which has 594. But again, we've got significantly more than a number of states. If you're looking at how widespread they are across Indiana's landscape, sort of tough to tell from this map, but you can see we have anywhere from 5 to 9 species. And if you follow that yellow sort of line from northeast Indiana down to southwest Indiana, that is the Wabash River. We have a number of endangered mussels in the Wabash River watershed. Um, but we have more than just mussels. When we think about endangered species, most of us think of things like polar bears, bald eagles, things such as that. But those endangered species, almost 1,600 nationwide, include things like a variety of plants, insects, reptiles, and we also already talked about clams and mussels. Just to give you an idea of the distribution, you can see, and again, they've been tracking this since the 1970s. The majority, the growing majority of endangered species are actually flowering plants. Some of the other categories of endangered species have remained relatively static over that time, but obviously a wide variety. And again, nationwide, we're talking about over 1,600 different endangered species. So the question is, if this requirement has been around since 1973, and if EPA has been registering pesticides since 1973, why are we only really hearing about this and the potential impacts now? Well, the reason is that over that time period, less than 5% of EPA's registration decisions have actually taken endangered species protection into consideration. So bottom line, EPA has not been complying with what the law requires, and as a result, a number of folks have sued EPA for failure to implement the Endangered Species Act, and EPA is losing. And now courts are making the decisions for EPA that you will either adjust these registrations considering the impacts on endangered species, or we, the courts, will start making decisions for you. And the courts can impose deadlines. You need to get this done by a particular date. And they could, but courts could also, if they think the risk is too great, could vacate registrations. In other words, the courts could ban the products. EPA won't have to, or won't have the opportunity to. So, these lawsuits have lit a fire under EPA. So EPA has been required to develop a work plan of how do we take care of all this backlog, and how do we start implementing endangered species protections into our registration decisions. And I'm not going to go into the details now. I do have a few more slides, but I don't think I have time for them. But what it's going to mean ultimately for the pesticide users, that there are going to be potentially more restrictions on how and where you're allowed to use a variety of pesticides. And I will tell you that EPA is starting with the largest pesticide user group first, which is agricultural pesticides. But these requirements ultimately will apply to all products except homeowner use products. That's the plan right now. In the meantime, so the question is, will the Endangered Species Act restrictions impact me? And the way you figure that out is you go to the label, and if you see an endangered species statement on the label, it will instruct users to go to a website called Bulletins Live 2. You go to that website, and you click on your state, and you see if there are any protection areas in your state for the use of a particular product. So right now, probably not too many restrictions for the products you folks use, but I guess the take-home message is they are on their way. And with that, I see I'm just about out of time. I'll conclude my comments, and I'll close by saying I appreciate again the opportunity to visit with you again here today. I know we've covered a lot of information. I hope to be able to, if you have questions, be able to address those questions as best I can. And as I indicated earlier, when you view this, there may be a chance I may have some updates for you on the regulatory front. And with that, I'll say thank you, and I'll conclude my comments.